Next case. Next case is a response to a letter to the Department of Labor dealing with the gig economy. It is dealing with the contractor employee distinction and answering some questions as to who is a contractor and who is an employee. So this is a fairly paramount interest to companies like Uber and Lyft and other companies which are doing the gig economy. Who is an employee? Who is a contractor? And what does it mean to be one or the other? So we're going to read this letter and see what they have to say, because this is obviously going to be, it's not controlling authority. Obviously, only a court can control, but it's an opinion, and so it's entitled to substantial weight. So, this should be fairly informative. This letter responds to your request for an opinion on whether service providers working for a virtual marketplace company are employees or independent contractors under the Fair Labor Standards Act. This opinion is based exclusively on the facts you have presented. You do not seek this opinion for any party that the Wage and Hour Division is currently investigating, or for use in any litigation that commenced prior to your request. You write on behalf of your clients, a virtual marketplace company that operates in the so-called on-demand or sharing economy. Generally, the VMC is an online or smartphone-based referral service that connects service providers to end-market consumers to provide a wide variety of services such as transportation, delivery, shopping, moving, cleaning, plumbing, painting, and household services. So I'm thinking here like TaskRabbit would be the one of them, or one of their brethren would be the one that comes most to mind that does this kind of work. This helps consumers to obtain these services with greater efficiency, days, weeks, or months faster than they would outside the virtual marketplace. This accomplishes this through a software platform called an analytic hierarchy process, a technological structure for organizing data that uses objective criteria to match consumers to service providers. Regarding your client specifically, before your client allows service providers to use your platform, it requires them to provide certain basic information: the service provider's name, contact information, and social security number. Service providers must also self-certify their experience and qualifications, complete a background check through an accredited third party, and complete an identity check through a different vendor. Your client also requires them to acknowledge and accept terms of agreement and a service agreement, which states that your client provides only a platform for connecting providers with customers, and disclaims any employment relationship between your client and the service providers. Additionally, these agreements state that only the service providers and not your clients will provide services to customers in the marketplace. These agreements also classify the service providers as independent contractors. Your client does not interview service providers or require them to undergo training. Once the service providers have begun to use the virtual platform, it provides them with information on how to use the virtual marketplace, such as tips on best practices, through an online resource center, and feedback from existing users, both consumers and service providers, on the level of service that customers generally expect. Your client does this entire onboard processing and does not require service providers to review any of the materials. Your client also allows service providers to immediately begin providing work for customers once their account is activated, and does not require them to report to a physical office. Your client's platform consolidates information from consumer requests, such as the kind of service needed, location, date, and time, and provides that information to service providers through the virtual platform. The platform also allows service providers to communicate with consumers, including through the mobile app, messaging, or mass telephone calls, to exchange details about requested service, including adjustments to scope, price, or time. Your client allows service providers to arrange for repeat business with the customer, including for future jobs outside the virtual marketplace. Customers using the client's platform pay services on a per job basis. Your client sets default prices based on region and scope of the provider's work, and uses default price tiers that correspond to the number and type of services being offered. It also allows its service providers to request, presumably from the customer, to charge different prices based on other factors, including work experience outside the virtual marketplace. Finally, your client issues its service providers a 1099 reflecting earnings. Your client agreement allows service providers the right to, among other things, accept, reject, or ignore any service opportunity on the platform, determine whether to accept any service employments at all, Select service opportunities by time and place. Determine the tools, equipment, and materials needed to deliver services and hire assistants or personnel. Your client's agreement provides that it will not inspect a service provider's work for quality or rate the performance. Your client, however, does let consumers rate its performance. Your client's service agreement allows providers to provide services to consumers through other means, including competing platforms. Your client does not require a service provider to accept or complete a minimum number of service opportunities. Your client designates a service provider as inactive if they've not taken a job for a certain period of time, but inactive service providers can reactivate their account with a telephone call or email. Your client also gives service providers the right to multi-app, that is, simultaneously work for a competing platform, in order to determine the most desirable opportunity. Your client's providers often make use of this ability. Your client service providers design their own schedules to determine when, where, and how to work within the marketplace. Few of them spend full time hours providing services through the platform. Service providers may consider a number of factors when determining whether to accept work, such as, for example, the fee amount, expected time, dynamic pricing and effect, location, availability of parking, traffic, and access to additional consecutive opportunities in order to maximize their profit or fit work into the schedule. Moreover, service providers may choose to accept more difficult jobs that are more lucrative and jobs with less revenue potential according to potential needs and profit motives. However, if the service provider cancels an accepted opportunity without sufficient notice, your client will charge a cancellation fee on behalf of the consumer. Your client collects these fees to maintain the integrity of the platform. Your client does not impose requirements on how its service providers must perform their work, such as what transportation routes to take, the order in which to clean an apartment, or the make, type, brand, source of working materials. The fact they talk about order in which to clean an apartment now is making me think of like more of a maid service, perhaps one of these services that provides maid services, because that's fairly specific. Your client is not present when the service provider works and does not monitor, supervise, or control the particulars of the work. Moreover, your client requires service providers to purchase at their expense all their own supplies and equipment. Your client does not reimburse them for operating expenses such as transportation costs, vehicles, professional certifications, or licensing. Your client will seek to terminate its relationship only if a service provider who commits a material breach, such as inappropriate behavior to a consumer or to the service, fraud, repeated cancellation, or scheduling of service opportunities on short notice, or receiving an aggregate consumer rating below a minimum threshold. Your client will initiate this termination process only in those instances to maintain the integrity of the virtual marketplace. The Fair Labor Standards Act applies to workers who this act defines as employees. An employee is any individual who an employee suffers, permits, or allows employees to work. This definition is very broad, but is obviously not intended to stamp all persons as employees. For example, independent contractors are not employees. Citing a U.S. Supreme Court case stating that recognizing workers may be independent contractors when their work does not, in essence, follow the usual path of an employee. Over the history, we've consistently applied the interpretation of employee that adheres to the text of the FLSA and judicial precedent interpreting it. An employee, as distinguished from a person who is engaged in business for him or herself, is one who, as a matter of economic reality, follows the usual path of an employee and is dependent upon the business for which he or she renders service. The employee-employer relationship under the FLSA is tested by economic reality and technical concepts, is not determined by common law standards relating to a master and servant. As reflected by the long-standing interpretation, the touchstone, that is, the central factor, if you like, of an employee versus independent contractor status has long been economic dependence. The Supreme Court has instructed that a worker's dependence should be assessed in the light of the purposes of the Act. Thus, for example, as broad of the definitions as employee and employee are, they cannot be interpreted so as to make a person who only serves his own interests as an employee of another person who gives him aid and instruction. While a statutory definition is exceedingly broad, it does have its limits. Whether a worker is economically dependent on a potential employer is a fact-specific inquiry that is individualized to the individual worker. The inability of a worker to work for his or her own terms suggests dependence. Accordingly, independent contractors are often characterized by their ability to, for example, regularly negotiate working conditions or simultaneously work for another business. When determining economic dependence, we consider 6 factors that are derived from precedent: the nature and degree of the potential control of the employer, the permanence of the relationship with the employer, the amount of the worker's investment in facilities, employment, or equipment or helpers, the amount of skill, initiative, or judgment or foresight required for the worker's services, the worker's opportunity for profit or loss, or the extent of integration of the service into the potential employer's businesses. Other factors may also be relevant, and the appropriate weight given to each factor depends on facts. Additionally, the determination of status does not depend on isolated factors, but rather upon the circumstances of the whole activity, the collective whole. Therefore, we do not determine employee status by simply counting factors, but by weighing those factors in order to answer the ultimate inquiry of whether the worker is engaged in business for him or herself or dependent upon the business for which he or her serves. The first factor is the degree and nature of employer control. A business may have control for, for example, it requires a worker to work exclusively for the business, disavowing working for or interacting with competitors during the working relationship, work against the interests of a competitor, work in flexible shifts, achieve large quotas, or work long hours so it's impractical to work elsewhere, or otherwise face restrictions on or sanctions for economic external opportunities, among others. Second factor is permanence of the worker's relationship with the potential employer. Permanence arises where a business, for example, requires a worker to agree to a fixed term of work, disavowing working for or interacting with competitors after the working relationship ends, or otherwise face restrictions on or sanctions for leaving the job in order to pursue external economic opportunities, among others. Additionally, the existence of a long-term working relationship may be indicative of permanence. The third factor is the amount of a worker's investment in facilities, equipment, or helpers. If a business makes these investments and provides them to a worker, the worker may come to rely on the businesses to supply those investments in order to perform the services. That reliance could make it more difficult for the worker to pursue other economic opportunities, thereby increasing dependence. The fourth factor is the amount of skill, initiative, judgment, and foresight required for services. In Rutherford, for example, when a business profited from alleged independent contractors' work, the business's profits were not because of the worker's initiative, judgment, or foresight, as would be expected from an independent contractor. Instead, the profits from the work were simply more like piecework. How a worker acquires a skill is also relevant. Among other things, if the company provides all workers with the skills necessary to perform the job, this suggests an employee status. The fifth factor is the worker's opportunity for profit or loss. These opportunities typically exist where a worker receives additional compensation based on, not on greater efficiency, but on greater exercise of initiative, judgment, or foresight, has the flexibility to renegotiate compensation throughout the working relationship, or has a capital expenditure at risk in the job. Opportunities for profit or loss can be indicative of an independent contractor status, even if the worker is not solely in control of the profit or loss statements. The sixth factor is the extent of the integration for worker services in the potential for employee businesses. For example, a worker's services are integrated in the business if they perform the primary purpose of the business. In short, while the FLRA has a very broad scope of coverage, it's not so broad that all workers are caught within its reach. Far from it. Recognizing this limitation on coverage provides freedom to workers to operate as independent contractors and remain outside the FLRA scope. FLSA scope. Apologize. Based on the facts you provide in the letter, it appears that your service providers who use your service are independent contractors. Your client provides a referral service. As such, it does not receive services from service providers, but empowers service providers to provide services to end market consumers. The service providers are not working for your client's marketplace. They are working for consumers through the marketplace. They do not work directly for your client to the consumer's benefit. They work directly for the consumer to your client's benefit. It is therefore inherently difficult to conceptualize the service provider's working relationship with your client because, as a matter of economic reality, they are working for the consumer, not your client. Indeed, because they are similar to healthcare providers who use a home care registry to obtain clients, workers whom we have previously stated can be classified as independent contractors under appropriate circumstances. Thus, it appears your client service providers do not fit any of the traditional employment paradigm covered by the Act. Under consideration of the circumstances of the whole activity, we do not see any indication that the service providers are economically dependent on the client within the meaning of the statute. A discussion of the factors demonstrates why. Your client does not appear to exercise control. Rather, your client gives service providers significant flexibility, including the ability to pursue external economic opportunities. First, your client does not impose any duties such as strict shifts, large quotas, or large hours. Indeed, your client gives flexibility to choose when, where, how, and for whom they will work, and they regularly use this flexibility to their own profit and personal advantage. The service providers therefore have complete autonomy to choose the hours of work that are most beneficial to them. Indeed, your client does not even require them to perform a minimum amount of work. This freedom enables them to pursue any and all economic opportunities at their leisure. Moreover, their ability to work full time in the marketplace, but most of them choose not to, which may be indicative that they're pursuing jobs outside the platform. Your client provides that services provide for the work to work simultaneously for competitors, and they routinely do so in order to maximize their profit. In fact, they will multi app. There is simultaneously run your client's app along competitors to compare opportunities in real time and pick the best opportunity on a job by job basis. By giving them the right to multi app, your client has relinquished control over the external opportunities. Your client even allows service providers to cancel jobs in order to pursue external opportunities on a competitor's platform. Your client also requires service providers to pay a cancellation fee only if they cancel a job without providing adequate notice. Moreover, your client does not inspect a service provider's work for quality or rate the service. Indeed, your client does not impose requirements on how they must perform the work, nor is it present when they do the work, and it does not monitor, supervise, or control the particulars of the work. Your client lacks control. It weighs in favor of the service providers being in business for themselves. The service providers have complete autonomy to choose the hours of work that are most beneficial to them, may simultaneously work for your competitors, and are subject to minimal, if any, supervision by your client. Indeed, this weighs heavily in fact of independent contractor status. Your client does not appear to have a permanent working relationship with the service providers that would be indicative of an employee-employer relationship. In fact, the service providers appear to maintain a high degree of freedom to exit the working relationship. More importantly, your client does not restrict them from interacting with competitors, either during the relationship or after the relationship ends. Your letter does not indicate how long providers typically remain active on the marketplace. However, even assuming in light of your promise that will terminate only for cause, the service providers maintain a lengthy working relationship with your client, they do so only on a project by project basis. This weighs in favor of independent contractor status. Your client does not invest in facilities, equipment, or helpers in behalf of the working providers. Instead, your client requires the service providers to purchase all necessary resources for work and does not reimburse for those purchases. Your client primarily invests in its platform, but those investments do not alone establish an employment relationship with the providers who use the platform because they are not investments in the work of that they perform. To be sure, the service providers rely on the software to quickly obtain jobs, but their reliance only marginally decreases their relative independence because they can use similar platforms. Your letter does not specifically identify what types of services are offered within the marketplace. However, regardless of the services your client provides, like the drivers in Salem, they choose between different opportunities and competing platforms and exercise managerial discretion in order to maximize profits, thereby showing considerable independence. Additionally, your client's providers do not undergo any mandatory training. The fact that they do not appear to rely on your client to provide them with training also is demonstrative of economic independence. Your client's service providers do not receive a predetermined amount of compensation for their work, but instead control the major determinants of profit and loss. Your client sets default prices but allows providers to choose different types of jobs with different prices, take as many jobs as they see fit, and negotiate the prices of the job. They further control the profit or loss by toggling back and forth between competing platforms. Additionally, because your client charges a fee for canceled service, the service providers risk losing money if they do not complete a job they've accepted. The opportunity for profit or loss gives them a substantial amount of control over their level of compensation and therefore independence from the client. Moreover, service providers' flexibility to work for different platforms, choose how to perform their job, choose different jobs with different prices, negotiate the prices of the job, and choose whether or not to cancel a job is worthwhile, indicates opportunity for profit or loss, is driven by their own skill, not just their productivity. Your client service providers are not integrated into your client's referral business. First, the service providers who use the platform do not develop, maintain, or otherwise operate the platform. Indeed, and rather, they use the platform to acquire service opportunities. Your client offers a finished product to service providers. Its business efficiently operates and terminates at the point of connecting services and do not extend to the integral part of the service. They are consumers from that service from your client, and they negotiate with your client over the terms and conditions of the service. Accordingly, they're not operational into the business. Relatingly, the business's primary purpose is not to provide services to end market consumers, but they have provided a referral system that connects them with consumers. This lack of integration weighs in favor of status. Under the facts described in the letter, we conclude your clients. Providers are independent contractors, not employees. The facts in your letter demonstrate economic independence rather than economic dependence, in which a working relationship between your client and service providers. The FLSA therefore recognizes your client's status as independent contractors. We trust that this letter is responsive to your inquiry. So that is that. So that is so that's actually a really, really good summary of the law as it relates to employee versus contractor distinction. There are quite a few different tests that are used by quite a few different entities, but the test that used here by the Department of Labor is, in the broad sense, fairly reflective of the generalized tests that are used. You look for these kind of factors: the degree of control, the degree of independence, the degree to which you can set hours, who uses what equipment, who sets what hours, who sets what pay, when can you negotiate, can you work for competitors. These are the kinds of factors that are relevant to the employee versus independent contractor distinction. And so, based on the facts as presented, I would agree with the Department of Labor that these are more reflective of independent contractor status. And as the Department of Labor points out, there is no one factor that's dispositive. It's a holistic inquiry. So depending on, it could be one factor changes. If it changes enough, if it changes substantially enough, it could outweigh all the other factors. So there's no like one test. You have to look for these in combination. And on the whole, I would say in combination that this is well on the side of independent contractor. But you have to watch out for this. And companies like Uber and TaskRabbit and others, they have to be careful on which side of the line they're on. And this is setting out a good benchmark for how to determine when you are and are not an independent contractor. So a very good review of the law, very good summary, and I think therefore was worthy of our time.